Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments now so that I may answer your questions. I'm both on YouTube, so I'm on YouTube a little later than usual, but I still wanted to come on to provide you good information. And I'm on Instagram today. Go ahead while I'm talking, put your questions in the comments and I will be happy to help you. So today I want to talk about a topic that I don't think I've touched on lately, and that is going from the 2-year green card to the 10-year green card without the spouse. Now, what's the 2-year green card? So for those of you who you haven't even reached a 2-year process, you're gonna want to know this. For those of you who are currently married, so you're newlyweds, you've been recently married, it's under 2 years since you've been married and you're about to apply for the green card. You're going to want to know this because if at the time you're approved for the permanent resident, you're married to your spouse for less than 2 years, you're going to get a 2-year green card. This is called the conditional green card, conditional permanent residence. And what this means, it does mean that during this time, during the time, even afterwards, while you're going from the 2-year to the 10-year, you will be a permanent resident. You'll be able to do everything that a permanent resident does. You'll be able to travel. You'll be able to work without having to get additional permissions to work. You'll be able to carry on with your life as a permanent resident. The difference, though, between the 2-year and the 10-year is once it gets to 90 days before the card expires, the permanent residence expires, you must jointly file with your spouse. Jointly filed means that your spouse has to be available to sign the same form as you, called the I-751 form. No, it is not the I-90 form. So don't fill out that I-90 form if you're going from the 2-year green card to the 10-year green card. Those are two completely different forms. For the I-90 form, it's where you already have your 10-year and you've gone through 10 years and you're renewing it, or maybe you lost your card and you have to do the I-90. For the I-751, it is specifically for removing conditions on a 2-year to change it to a 10-year. So be mindful of that. I have gotten individuals who come to me after they've submitted an I-90, and then a year later they realize that that was the wrong form. Now, your spouse and you will have to file jointly. However, there are some exceptions to this joint requirement, meaning you can apply without that spouse under certain circumstances. And this is what I want to focus on today. Now, 90 days, usually 90 days, this is a tight deadline and it is a strict deadline. If you go beyond that, you may be able to still file late, but you have to have a good reason for filing late. If they do deny that, you might be in hot water and you might find yourself in removal proceedings. So make sure you're mindful of the deadline. You must apply within 90 days before the expiration of your 2-year residence. Now, if at any point you're about to apply, you're in the 90-day period, or you even after the 90-day period, if at any point you get divorced, you get separated from your spouse because of mistreatment, and then in addition, new conditions have now come up in your life that will cause you extreme hardships. If you don't get your status extended, you could qualify for one or multiple of these waivers. If your spouse mistreats you, it's still VAWA, but VAWA in regards to the 2-year to go to the 10-year. Yes, VAWA does apply to the conditional residence as well. That's the good news. So that means that if you're being verbally mistreated, you're being mentally, emotionally, financially, physically, even though I also want to note here Physical harm is not required. Physical threats, not required. Police reports, not required for this type of filing. And I have succeeded on less than that. So based on emotional mistreatment. So it is possible. And so I want you to know, if at any point you were disrespected, called names, blackmailed, that's a common one where you're constantly being blackmailed about your status and whether or not they're gonna, today they'll say, oh, I don't think I'm gonna do that joint filing for you to get the 10-year. Then tomorrow it's a different story when they get what they want. And if this is the cycle that you're experiencing, then this will qualify. That will qualify you for this form of relief, because nobody deserves to be going through that kind of abuse. That's abuse. Nobody deserves to be extorted or blackmailed and abused in this way. So if you're going through a situation like that, just know that you do have a way to apply on your own. This VAWA, where you can apply without the spouse, you can do it even if you're still in the house with the spouse. We make sure that you are safe throughout the process, because you are in the same household. We want to ensure your safety, and we treat this in a very confidential way. We're very careful with how we communicate with you. And so to make that possible, but that is possible, even if you're in the same household with a spouse. If you're separated but not divorced, this is also a possibility for you. And if you're divorced, this also qualifies you for two waivers: the divorce waiver, where you have to show that the marriage is bona fide and that, the marriage just didn't work out. That happened. And then also the mistreatment waiver. You do have to show that the marriage was bona fide. However, you can qualify for both of those. So there are three types of waivers, circumstances where you get to apply on your own. But keep in mind, it's not a matter of just filling out a form, an empty form. It's not about forms here. What it is about is presenting your case in a way that's going to be acceptable to the USCIS, credible to the USCIS, for them to accept it as evidence. And so filling out the form, that's the easy part, right? It's the work that goes behind it. So what I am doing now is telling you that this may be a form of relief for you. So what you need to do is take the steps, protect yourself, make sure you get the legal advice. Because remember, the information I'm giving today is not personalized legal advice specific to you. It's general information. And so to determine whether you qualify is going to come down to your particular circumstances. Now, keep in mind, I just want to add this too, that this is not for fake marriages, right? Because that's what the 2-year to the 10-year green card is sifting out. They're trying to determine, it's a probationary type of period where they're trying to sift out whether this is a fraudulent marriage. So if you paid this person to marry you, got through the first phase, you got your 2-year, and now you're looking to get your 10-year, but now this person you paid is being shady and they're not cooperating, you will not qualify, right? Because this is only for real marriages. It's not for any kind of, I paid my money and this person isn't cooperating. That's against the law. And this is exactly what they're looking for to be able to remove you. So that's a word of caution. Don't ever enter into one of those arrangements, because I have seen these nightmarish situations. I've had multiple people come to me. They're just feeling lost, where they have paid someone to do this, or they've gone into an arranged situation, and then this person disappears on them. They either don't file the papers or they back out of the situation. And they, sort of come to me like, well, they're not fulfilling their customer service, I guess. And at that point, I do have to explain that that's fraud and it's illegal. And yes, people take your money and they run. One reason why it's not the right process for you. Individuals have also come to me and they have said, well, why do I have to go with the legal option that you're telling me when I can just get married and do it that way? Well, that's because, so for example, VAWA versus getting remarried. One, with VAWA, it's your process, right? It's your process. You sign the papers. It's your legal process, and it's based on your real experience, right? You deserve justice. You deserve relief. You have it, when I'm representing my attorneys, I work hard representing my clients, I work hard for them. And they can always depend on me. They can always call me. If they have any concerns, I'm there to address their concerns. And it is a legal process that you qualify for. You actually qualify. At the point that I'm explaining to you that you have a good chance at getting approved for this, that means that I am very careful about the clients that I select. And when I do select you, it means that I do believe in your case and I'm going to advocate for you. So I don't just take anybody to represent. I do select who qualifies, and I represent you based on that. When you do it the shorthanded way, you think it's going to be the easy way, and it turns into a nightmare. I've seen them back out, blackmail them, abuse them, demand sexual favors from them, run away with the money, go to the USCIS and Immigration Service and actually tell them that, yes, this was fraud. Sometimes the USCIS or the Immigration Service already identifies. They just know the red flags, just like I'm able to tell sometimes the red flags, and they can see it too. And they also will back you up, back your partner up, and then basically let you know that they know this is fraud. So that's just a cautionary tale about choosing the legal options versus these shorthanded ways, because it's going to come back and bite you in the butt. And sometimes with the 2-year, going from the 2-year to the 10-year, that's where it bites you in the butt. Is you may have succeeded with the 2-year, and then you get to the 10-year, and then you find that fraudulent marriage is now coming to light. So just a word of caution. But now, as long as you're in a bona fide marriage and you're going through this mistreatment, you're going through any form of mistreatment, or you're in a bona fide marriage and it just didn't work out, that's fine. This is where you qualify to do it on your own. Your well-being is of the utmost importance. And so if divorce is what's going to ensure your well-being, go ahead and do that. And just make sure you gather the documents in preparation to apply that prove that you have a bona fide marriage. Same with the VAWA. Just make sure you're gathering updated evidence, by the way. Another thing that I find is people will carry the old evidence that they already gave the USCIS. They'll carry that as evidence that their marriage is still real. That is going to be a sure denial here. They want updated evidence, right? They don't want to see the old evidence before you got your green card. What they want to see is, how have you and your spouse been living since you got the green card? So in the year and 9 months, or the last 2 years that you've had your green card, how have you and your spouse built a life together? That's what they want to see. And the evidence is going to be different based on the type of relationship that you have with your spouse. That's where it's important to get legal advice and representation, because it's not a one size fits all. Clients' marriages, they have different arrangements, different financial, ways that they organize their finances. Some have children, some don't. Some maybe don't even live together for some reason. Some are separated. Some are getting a divorce. So all of that is going to count in regards to what type of evidence is going to be appropriate to show that this is a bona fide marriage. So those are the three ways that you could apply for the 2-year to the 10-year green card without the spouse. Just know that you have an option. And then also keep in mind that if you do get approved for the VAWA waiver, you're able to apply for naturalization within the 3-year period or after 3 years of having your permanent residence. So you still get the benefit of applying within the shorter time period, which is great for VAWA applicants. Now I am going to open up for questions. So go ahead and put your questions in the comments and I'll be happy to answer. I see a number of questions on YouTube and I see some questions also on Instagram. So bear with me while I go through these questions. So what if you are in a process of removal of conditions and waiting for interview schedule, then you get separated when you receive your scheduled interview? Thanks so much for raising this, because this is one of the important points. You can apply for this waiver at any point. So after you jointly filed, and I've succeeded in this situation where the client was smart enough to get me on board ASAP and we're able to file the waiver. But the waiver is still going to be essential here. If you have already been scheduled an interview, the time is of the essence here to make sure you're prepared for that interview. Because that waiver, they do want us to get an official submission of a waiver and with the evidence, the relevant evidence, but it's never too late. It can be filed at any time before the 90-day period. So that's another thing. If you got separated, at any point before that 90-day period, if it's beneficial, that's where it's important to have a conversation with an attorney, and that's what I'm here to help with. But if at any point you get separated before it's time to renew, you could use the waiver and apply before that 90-day period. You could apply even if you're in the middle of the process now with your spouse, you could apply for the waiver once they're out of the picture. But you have to be prepared, because if you go to that interview and you don't make it clear, some officers will on the spot, they'll listen to what your situation is and they will go ahead and ask you if you want to apply for a waiver. But that's not always the case. So it's always best at this point, important to schedule a consultation to get the legal advice you need and representation. Because going into the interview, some officers may just look at the form and determine you never filed a waiver. So they're not going to make a decision on a waiver and deny you based on the spouse not showing up at the interview. So to avoid things like that, get counsel involved and make sure you do it right. This is your future. You want to make sure that you don't have, you try to make it as smooth as possible. So hi, I married a citizen and this week I received the I-130, 765, I-485 receipts and the notice of action. Okay, great. But they don't have an A number. Is this normal? So usually they do assign an A number. You can always call them and inquire into that. I was married at 10/2016, received 2-year green card at 9/18, divorced at 10/19, green card expired 9/20/20, filed for waiver at 8/20/20, still proceeding time with extension, and that's normal. Can I apply for naturalization at 9/20/23? At police report from 6/19. So while I can't advise you specifically whether you could apply for naturalization, what I can say is it is possible to apply for naturalization at the same time that you're still waiting to get the conditions removed on your 2-year. Sometimes what they'll do is they'll call you for the interview, and then after you've passed the interview to get the 10-year, they'll jump straight into a citizenship interview and grant them at the same time. But sometimes they'll do 2 separate interviews as well. It just depends on how they decide to process it. What if you already filed for removal of conditions and you received the interview? What will you gonna do? Okay, so I answered that question. I saw an article about administration going to make Green cards available for immigrants in December 2022. Don't understand who qualifies for this. So you may be looking at the article that or articles that's talking about the visa limits in regard to employment based. But I don't know what article you're referring to. You'd have to be a little more specific about that. But unused, so you have visa numbers that are available for family-based immigration, and if they're unused, they go to employment-based, and they are saying that they are going to make sure to use all of them for the employment-based, because some of the employment, they have a lot that are available, and so they're trying to move along the backlog cases using those available numbers. All right, so I'm going to keep going through. Can you file for citizenship if you divorce your abusive partner? Now, it depends on, this is where the consultation is going to be very important, because it depends. When did you divorce them? Did you have your 10-year? If you never applied for VAWA, then it's very unlikely that there's any documentation that you'd qualify for early citizenship based on the citizen partner that you had. However, if you applied and succeeded with a VAWA petition or application, then that citizenship within the 3 years would be possible. I have advanced parole. How safe can I travel? You'll have to talk to your attorney. It's really specific to what your situation is. That's where it's important to get legal advice and representation. Can you please explain how long a K-1 visa can usually take in time? It depends on the embassy, depends on what's going on in your case, but I would say anywhere from 12 months to 18 months right now. Married to a man, but woman living in Canada. The guy get a divorce without letting her know. So is the process canceled? Get legal advice. If they got a divorce without you knowing, yes, there is going to be a problem there, because it means you don't have a marriage. But I want to understand fully what's going on here. So schedule that consultation. To schedule the consultation, go to the link in the profile. It's going to take you to the website where you will see everything you need to schedule your own appointment, or where you can go to the website and look at the various ways to get in touch. We have online chat, we have a contact form, we have the phone number there as well. And then we have the appointment page where you can schedule your own appointment without calling. So it's so important to do that. So I noticed you followed up here with, they were doing a waiver for her, but without a husband, everything is canceled, right? So if I still don't fully understand the facts here, and this is where the consultation is going to be very important. This is why consultations are very important. You can never expect to get a quality specific legal advice in a live with an attorney. That's not going to happen. You have to make sure you schedule so I can do a detailed evaluation of the facts involved to understand what happened and whether there is still relief available. Oh, thanks so much, F. Nero. Hi, Ricky Flossie. What's next after getting a prima facie to wait for that decision? Sounds good, Ricky Flossie. All right, keep those questions coming. Sponsorship, how to convince the employer to do it for me. So that is not necessarily a legal question. Once the employer decides that they want to hire the employee, that's where I come in. But I don't really have anything to say about how to convince them. Usually the employers, they're used to this, or they've already made that decision. So it's just a matter of finding the right employer. I was out of country for 2 years, 2019 to 21. I have a 10-year due to expire 2024. Do I need to wait until I file taxes to file for citizenship, get legal advice? Your situation is going to be more complex. We'll be in touch soon. Okay, sounds good. If you haven't started filing any paperwork and you got divorced from an abusive partner, can you file on your own? This is a great question. Thanks, Shantae, for that question. Absolutely. But the clock is ticking. Clock is ticking. Deadline is coming. If you've been divorced from this abusive partner who has to be a US citizen or a legal permanent resident, if you've been divorced for less than 2 years, you qualify. Once it hits the 2-year mark, you are now disqualified from applying for this. This is what I help my clients do. So go ahead, give us a call, get on it right away, because that 2 years can fly by and you could find yourself you could find yourself losing an opportunity to get the relief that you truly deserve. You deserve this. You deserve to get the relief, especially after going through the ordeal of escaping an abusive marriage. Now, this form of relief based on divorce will not involve the ex-spouse. They will not be contacted. As a matter of fact, they make sure to protect any information you have on record so that that person is never notified of this. They don't share information with the outside agencies. So just go ahead, do this right by yourself and get legal representation. I'm ready and available to help you with that. What's the last documents you have to write up for a petition? So I'm not sure what petition. There are so many petitions, so many different forms of benefits and relief. What happens when U.S. spouse withdraws AOS application twice consecutively with false allegations and intentional sabotage? That's abuse. And we have seen situations like this with our clients. So go ahead and call, schedule an appointment, and we can talk more, determine what happened, and then get started. Now, it's definitely more complex when they do bring, for example, allegations of marriage fraud to the USCIS. It becomes more complex. However, these are false. Then you want to make sure that you act on it to get the legal advice and help you need to get going and moving forward with your life. So go ahead, call. On YouTube, I'm gonna go ahead and put my contact information. So it's stlawoffice.com, and then also 561-405-4889 is the number. I'm the immigration attorney on Instagram. If you go to the link there, you can see everything you need to get in touch. You can even schedule your own appointment. How long is the VAWA taking currently from point of filing to successfully being granted or denied? So it's taking about 2 years to 2 years to 2.5 for the VAWA. And then to get the green card, if you file everything, it's going to be about 2.5 to 3 years. However, keep in mind that the work permit, you do get the work permit and you do get the social security number and relief in between. The work permit is 2 years, so it does offer my clients much needed relief while they wait for the final decision. All right, that's gonna be it for me. I will see you on Monday. Thank you for your time. I come on Monday with all your questions. I'll be here 4:30 on YouTube, the usual time, around 4 p.m. on Instagram, around 4:30 p.m. Eastern time. Join me on Monday so we can continue having this conversation. It was nice seeing you. Hope to see you in the future. Hope to speak with you in a consultation. That's where you're going to get the information you need to move forward with your life and to make the right decisions for your case. All right. Have a good one. Bye-bye.